Hey notaries, Christian here with a new video, and we've got to talk about a notary's legal battle over signing by signature stamp. As a notary, would you allow a client to use a signature stamp to sign their document? Well, there was a notary who was surprised and unprepared to deal with this situation. The notary simply allowed the notarization to proceed like any other notarization, and while this seems like a very small, simple mistake, one major issue flourished from here. This notary ultimately ended up having to defend herself against a $1 million lawsuit. While the case involved other notary issues as well, it all started because of the signature stamp. The argument was made by the party bringing the lawsuit that the signature must have been forged, and in the case, the impression of the signature stamp was of such high quality that it was nearly impossible to tell the signature had been stamped rather than handwritten. This particular case revolved around a number of issues, including the definition of a signature, special requirements for a signature by mark, and proper journal keeping practices. What is a signature? The legal definition of a signature is in virtually every state focus on the intention of the signer. Thus, a signature is any writing, mark, or symbol intended by the signer to serve as his or her signature for the purpose of authenticating the instrument on which it appears. The most common kind of signature is the standard handwritten John Hancock. However, a mark or symbol such as the image of a coat of arms or other graphic image that is drawn by hand, stamped, or embossed onto a document would constitute a signature if applied by its authorized user with the intent to serve as a signature. For instance, in ancient times, members of the clergy, the nobility, and other persons of wealth often used the impressions of the unique images on their signet rings as their signatures. Today, the most common analogy is the handmade X, and you do not have to be illiterate or physically unable to write in order to adopt a X or symbol as a signature. Without question, a signature stamp applied by the individual whose name appears on the stamp constitutes a signature. In this case, the signer lawfully signed the document. Ideally, signers using a mark or symbol will have their names written by the mark on the document to inform other parties of the meaning of the mark, as some state notary statutes require. California. What is a notary's responsibility? In the state of California, a signature by mark is something uncommon, and this requires a notary to follow a specified procedure to validate such a signature. The purpose of the extra steps is to help protect against possible forgery and fraud. These steps require the notary to have one or two other witnesses observe the signature by mark, to have the witnesses sign the document which the signer signed, as well as though one witness signature must be entered in the notary's journal by the witness that writes the signer's name next to the signature by mark. I do have a detailed video on signatures by mark, which will be posted in the video description. So I know the way I worded this here, probably not the easiest to follow. I mean, it is like a procedure. It's better if you just see an example of it drawn out, and I have that. So I'm gonna go ahead and post the description to that video on signatures by mark. So just in case you don't know how to complete that, I do have a video that talks about exactly how to do that. And it'll be in the description, the video description. All right, guys, I have a detailed video on signatures by mark, which will be posted on the video description. As a safety precaution, I would record every official act in the journal, even if not required by California law. Any out of the ordinary event that occurs during a notarization should be noted in the journal as well. This applies to a signature by mark. Without question, a signature stamp applied by the individual whose name appears on the stamp constitutes a signature. However, I would personally not complete the notarization without a handwritten signature if the individual is not impaired, but that's just me. I would include the names and signatures of any witnesses. Also, remember, the journal entry should be signed by the document signer using the same mark, of course. So if you do happen to notarize someone that's using some type of mark, maybe a stamp or I don't know, something as their signature instead of a handwritten one, be sure to collect that exact same signature in your book, because obviously if you don't, it's going to look kind of weird, like, well, why'd you let them sign one way on the paper and then one way in your journal. I mean, if it's their signature, it's their signature, and they have to sign your book, however it is that they sign their signature. So yeah, if they use a stamp on the paper, put that stamp in the book. The verdict. In this case, the state where the notarization took place required its notaries to take special procedural steps when notarizing a signature executed by Mark. Yet the notary had not taken any of those extra steps. However, the notary had kept a detailed journal entry, and that entry identified the unusual circumstance of the signing of the document by a signature stamp. As a result, the notarization was valid. Fortunately, the jury and judge agreed, and the notary was exonerated, but not before having to go to court and defend her actions at a great expense. So the case was closed in the end, and she was fine. So that is great, and she should have been, because you know what? Like personally, like I stated earlier, I wouldn't, like, if they're not impaired with their hand, and I've never had this situation come up. I've never had anybody ask if they could get something notarized and not actually sign it unless they were impaired. Which case we would use a signature by Mark. But yeah, no one's ever like popped out a stamp and said, "Hey, can I use this instead?" While they have perfectly working hands. It would be kind of cool though. But because of the legality of it and the questions that might arise, and not only that, but the questions over my integrity would also arise, I would just recommend that they sign with their hand. You know, it's like, hey, can you just please sign it how it appears on your ID? Because at the end of the day, that's what we're supposed to be going by. But then again, if they do sign, if that is their signature and that is their intention is to sign something with that stamp, then that signature is valid. It's still a signature regardless of the method used. It's all about the intention. But yeah, like I said, I would much rather just, if they can, handwrite it, actually sign it, because yeah, we don't want these we don't want to have to go to court to defend ourselves, right? It's a waste of time. So, but yeah, fortunately it's never happened to me before. I've never had anybody ask me if they could use a stamp or something like that. Signature by Mark, yes, that happens. Probably like if I do, I'm not gonna say like maybe like 2 out of 100 signings, maybe. That sounds about right. Maybe 5 out of 100. It's not really common, but it does happen. Alright guys, so that does it for this video. Go ahead and check out the video description for that signature by Mark video in case you need any, in case you don't know how to do it. It teaches you. Alright, see you guys in the next video.